And thank everybody for joining our webinar today on business associate requirements and how to achieve a compliance. My name is Jana Langhorn, and I'm the Director of Marketing here at CynergisTek, and I'll be serving as your moderator today. In just a minute, you'll hear the presentation from David on the compliance requirements for healthcare vendors that are considered business associates, and he'll provide some guidance and tools on how to achieve compliance. But before we get started, I want to quickly go over some housekeeping rules. Please be sure to stay muted during the presentation, but feel free to ask any questions using the chat feature in the control panel of GoToMeeting. Please be sure to only send it to the organizers by selecting it in the drop-down box. And then about the last 10 minutes before the hour, we'll be sure to address any questions that are sent during the webinar, and we'll be able to unmute the lines for any other questions. Now, moving along to our session, please welcome David. He's the Vice President of Compliance here at CynergisTek. He's considered a subject matter expert in health information, privacy policy, and compliance issues involving the HIPAA privacy, security, and breach notification rules. He has over 10 years of experience in developing, implementing, and evaluating health information, privacy, and security compliance programs from both government and private sector positions. Prior to CynergisTek, David served on the Health Information Privacy team at the Department of Health and Human Services Office for Civil Rights, where he served as the Senior Advisor for Health Information Technology in the HIPAA security role. He led many OCR initiatives, including the effort to integrate the administration and enforcement of the HIPAA security role. He is admitted to practice law in the states of New York and Illinois. With that, I pass it over to you, David.
Thank you very much, Jana, and welcome everybody. Just a minor housekeeping matter. If you could please mute your phone, that would really be helpful. Welcome again. Purpose of today's meeting is to discuss and for many of us, refresh our memories as to the challenges and changes that resulted from the HITECH Act modifications that were issued in 2013, expanding the role and requirements, the definition and requirements of business associates. And for our call today, I'm going to break it up into 4 topics. And going to try very hard to leave a significant chunk of time at the end for questions as well as comments and concerns. During the slides, if you have a question, I believe that there is a chat feature available, and I encourage you to send your questions to us so that we can share them and hopefully provide some answers for you. The HITECH Act that was passed in 2009 and the regulations that were implementing it and that were not issued until 2013. If you think back to how the original privacy rule was developed and implemented in 2003, this is really, these changes that were in the HITECH Act are the first changes to the privacy and ultimately the security rules since their inception. And in fact, when you consider how the privacy rule came about, the privacy rule is unique or different than other regulatory schemes in that Congress really didn't have a role in developing the privacy rules as they were originally set out. If you look at the original HIPAA Act, there's nothing in the HIPAA Act which sets out the privacy and security standards. The HIPAA Act only sets the jurisdiction of who's covered by the privacy rules. And then the Department of Health and Human Services was empowered to go out and actually develop the regulations that we know of today as the privacy and security rules. Congress set that jurisdiction in the original privacy rules to only cover covered entities. And covered entities were closely defined as healthcare providers who were engaging in certain electronic standards, certain electronic transactions, which are the standard transactions that we know today, health plans and health insurers, and healthcare clearinghouses. So in the HITECH Act, Congress came back to revisit the issue of who's covered under the privacy and security rules, and expanded the jurisdiction, expanded who has to comply with the requirements of the HIPAA privacy and security rules to add some responsibility on the part of business associates. And in doing so, HHS looked at the HITECH Act and used their discretion to expand or to clarify the definition of who is a business associate. So all along we've thought of business associates as both sort of a regulatory definition as well as a functional definition. And so the functional definition is if there is a vendor or contractor who is providing services to a covered entity that requires the use or disclosure of the covered entity's protected health information, that vendor is considered or is by definition a business associate. What some of the changes in the HITECH Act, in the regulations implementing the HITECH Act that were issued in 2013, the definition in the regulation specifically calls out certain types of activities that are conducted by contractors or vendors to be business associates. And so for example, the OCR updated the definition to specifically call out health information organizations, which, if you look in the preamble guidance, what they really meant to say was health information exchanges, e-prescribing gateways, vendors who are providing transmission services and who have routine or persistent access, or the data is persistent on their systems, personal health record providers who are maintaining a PHR on behalf of a covered entity, and subcontractors to a business associate. And in addition to the functional consideration of who is a business associate, the requirements extend to having to safeguard or protect any protected health information. So that's PHI in its broadest sense, and it's in any form. It's in printed material, it's images that are conducted or created in X-ray, laboratory data, so long as it's created, received, maintained, or transmitted by or on behalf of the covered entity, an OCA, an organized healthcare arrangement, or another business associate. And that's a pretty broad and extensive scope of responsibility towards protecting protected health information. So the goal was to require that health information, protected health information, when it's created by a covered entity or on behalf of a covered entity, that it's protected from end to end. It's protected throughout its use and its transmission and its storage, from the covered entity to the contractor or vendor who's the business associate, to any subcontractor or business associate of a business associate. The goal was to secure or to safeguard information from end to end. one of the issues that is included or found in the business associate area is answering the question of who is a business associate and how do you address the question of routine access? Or another way to put it, what is a conduit? And the issue of conduit was first presented in the original privacy rule to find a way to lessen the burden on types of organizations that were handling materials that contained PHI. And in the original privacy rule, there was a discussion of defining a conduit or carving out an exception to the business associate rule for entities that handle PHI but really don't have access to it. And in the original privacy rule, they used examples like the Postal Service or a package delivery service like UPS. And they also used storage companies. And over the years, various directors at OCR issued private letter guidance to organizations, including organizations like record storage companies. And the issue of who is a conduit kind of took on a life of its own. And in the omnibus rule changes that OCR issued in 2013, they revisited this issue of who is a conduit and tried to set it back and to narrow it and to provide some real limits to its extent. So in thinking of what is a conduit, for purposes particularly in dealing with electronic protected health information, any service provider that provides storage of PHI, even if the agreement or the business associate agreement or the service or terms of use don't contemplate routine or access to the protected health information, they don't fall within the conduit exception. If they have any access to the protected health information and there's a persistence of custody, and that is the real measure. So an example would be if you are using Google to provide your email services for your healthcare practice. As we know, when you use Google, Google creates a copy of emails and other materials that are transmitted through their services, and in fact, they whether or not they access the information, they do maintain a copy, they store it, and it's retrievable for you as a part of the service. And for many years, Google would not offer business associate agreements. And they would claim that they were a conduit because they were simply, as they put it, they were simply moving an email message from one place to another. But as we learned in the case of Phoenix Cardiology, that really doesn't hold because Google created a copy of the email, and it was persistent. And whether or not they were accessing it, they could access it. And so if you examine the clarification and the preamble guidance that was issued along with the rule, the omnibus rule, that it changes the definition of who is a business associate, they clearly attempted to address this issue, that service providers who create a copy or maintain a record of an electronic transaction, they are business associates. And as a point of reference, after the adoption of the changes the omnibus rule in 2013, several large providers of storage and consumer level email services like Google, Amazon, and Microsoft, they all began offering business associate agreements and establishing services that were protective of the information to comply with the requirements of the HIPAA rule. One of the requirements under the privacy and security rule is that when you have a vendor or contractor who's providing these services, that you obtain satisfactory assurance. Satisfactory assurance that the vendor or contractor who's handling the protected health information will safeguard the information and only use and disclose it as permitted or required under the privacy rule. And most of these, in these satisfactory assurances, generally are going to take the form of a business associate agreement. We're going to go into some greater detail of what a BA agreement is, but for the purposes of this discussion at the moment, let's just say that the BA agreement has to contain certain elements, and those elements form an agreement in which the business associate, the contractor, or vendor can only use or disclose protected health information as permitted by the agreement, and the agreement itself does not create an authorization or the ability to use or disclose protected health information that is greater than what is permitted under the HIPAA privacy rule, the HIPAA security rule. One of the significant issues brought out in the changes in the omnibus rule is the requirement that business associates have to get satisfactory assurances from any subcontractors that they use downstream to handle protected health information. And this is the case even if the parties don't enter into a BA agreement. This also becomes an issue in the case of a breach or an unauthorized disclosure, because under the provisions of the business privacy rule and the breach notification rule, the business associate has an obligation to report any breach to their covered entity or the business associate that they are serving. So, in looking in the instance of the event of a breach, the chain of notification would be the reverse of the chain of contracting. So, in the case of a hospital that has contracted with a billing company to perform billing services on its behalf, it's the billing company is the BA of the hospital, and then the billing company contracts with a shredding company or waste removal service to take care of the paper waste that contains PHI. If there were to be a breach at the waste company, the can falls off the truck and spreads paper all over the highway. Well, that would arguably be a breach, and under the requirements of the business associate contract and the requirements of the breach notification rule, the shredding company would notify their BA or which was the billing company, who would in turn notify the hospital that there had been a breach. One of the significant changes in the omnibus rule also makes clear that the absence of a BA agreement does not change the analysis of whether or not there is a BA obligation. So this is a discussion in the rule regarding analysis using the federal rules of agency, sort of a technical legal issue. But when you boil it down, is if you have a vendor or contractor who's handling protected health information on your behalf, then they are responsible, as you are, for safeguarding the information. And by operation of law, HHS will hold both the business associate and the covered entity responsible for safeguarding the information. And the business associate, regardless of whether or not there's a written BA agreement in place, will be held responsible and liable for any omission in safeguarding the information or failing to meet their responsibilities as a business associate under the rule. So let's take a moment and look at the requirements for covered entities in working with vendors and contractors who are handling PHI. So continuing the requirement that was in the original privacy rule and the security rule, a covered entity has an obligation to have a BA agreement in place with any vendor who creates, receives, maintains, or transmits protected health information on behalf of the covered entity. And every BA is responsible for obtaining the BA agreement with any subcontractor or vendor or contractor that they use to carry out a function or activity that involves the PHI. The covered entities themselves are not responsible for obtaining the business associate agreement with the subcontractor. And it doesn't create an obligation on the covered entity to have any contract or agreement in place with these subcontractors. The relationship is wholly between the business associate, think of them as the prime contractor, and their subcontractor. So in continuing with the theme or the requirements that were in the original privacy rule, if a covered entity becomes aware of a situation in which their business associate is not living up to the requirements in the business associate agreement, or they're using or disclosing the PHI in a way that's not permitted under the BA agreement, the covered entity has a couple of options. They can terminate the relationship with the business associate and provide guidance, or they can provide guidance to the business associate to remedy their non-compliance. But if the covered entity terminates the relationship, they have to make sure that the business associate returns their protected health information or destroys it or disposes of it in a manner that's protective of the health information. Under the original privacy rule, the covered entity had the option of continuing their relationship with the business associate and filing a notice with the Secretary of HHS. The notice would say simply to the effect of, I know my BA is bad, but I can't live without him. That option is no longer available. The changes in the omnibus rule really only give the covered entity two choices. they can either terminate their relationship with their bad business associate, or they can give them guidance as to how they have to change their practices to be in compliance. But the OCR's position is going to be that once you've given them that one chance and they have proven that they can't comply with the rule, then you would essentially be forced to terminate your relationship with that vendor. So looking at the business associate agreement itself, the business associate agreement has to contain certain elements. It's a floor of certain requirements that must be in place to show and to put conditions on how the business associate, your vendor or contractor, has to safeguard protected health information. So the business associate has to comply or has to fulfill the requirements of the HIPAA security rule. The business associate also has to apply the minimum necessary standard that's found in the privacy rule, and they can only use and disclose protected health information as permitted or required under the privacy rule. That would be the first big standard in the privacy rule, 164.502. The business associate has to report breaches of unsecured PHI to the covered entity. And any subcontractors, as we said earlier, subcontractors are required to initiate or agree in writing to their business associate or the prime contractor to any changes, and provide assurances that they're going to safeguard the protected health information and only use and disclose it as the business associate could. And one important thing to remember is that the uses and disclosures that the vendor or contractor can take can't be broader than the uses and disclosures that are granted by the covered entity. Another important aspect is that if the business associate is going to carry out an obligation under the privacy rule, for example, individual rights of access, then this has to be stated in the business associate agreement so that the obligation is passed to the business associate. One thing to remember, though, is that even if the covered entity delegates one of these responsibilities that it has under the privacy rule, even if the business associate fails to carry out the obligation, for example, they fail to amend a patient's record or they fail to provide access to the individual that's been requested, it's the covered entity that bears ultimate responsibility for failing to live up to those requirements in the rule. So some of the privacy rule obligations under the for business associates is that business associates can only use and disclose PHI as permitted under the rule. And this is one of the expansions that was accomplished through the Omnibus Rule, expanding the jurisdiction of responsibility by business associates. And the business associate must also be in a position to provide a copy of PHI to the covered entity or the individual as directed in the business associate agreement. And the business associate agreement must also require that the business associate is required to disclose protected health information to HHS if it's performing a compliance review or a complaint investigation. In addition, the business associate has an obligation to provide an accounting of disclosures, the same accounting of disclosures that is set out in the privacy rule, where the covered entity would provide the accounting of disclosures to an individual for all disclosures except those made for treatment, payment, and healthcare operations. That same accounting of disclosures obligation is passed on to the business associate, and the business associate would provide that accounting of disclosures either directly to the patient or the individual, if that is how it is structured in the business associate agreement, or they would forward that accounting of disclosures up to the covered entity so that they can fulfill their obligations under the rule. In addition, the business associate is required to fulfill their requirements under the security rule, which essentially the security rule puts can be seen as having three large components of assuring confidentiality, integrity, and availability of electronic protected health information. So some of the considerations that come into play is when you have some conflict between the business associate and the covered entity. And it's always important to remember that because the covered entity is ultimately responsible for the safeguarding of health information that it's being created or used or maintained on its behalf, it's the covered entity who's really the boss of the relationship. And so prior to disclosing or passing on health information to a vendor or contractor, they should have some considerations as to who's in charge of this relationship, and if they have an entity or a vendor who's unwilling to execute a business associate agreement, they should carefully examine the relationship and whether or not this vendor or contractor is an appropriate choice for them. So one way to consider and to assure that you're in compliance with the privacy and security rules as a covered entity, and also to have a better management approach to safeguarding your health information, whether it's in paper form or digital, is to have a process to understand who is a business associate and who's not a business associate. And we're going to dive a little bit deeper into these vendor management relationships in just a moment. But one of the important provisions or actions that you can take is to make sure that you are using a business associate agreement that fulfills the requirements of the HIPAA privacy and security rules. An organization can develop their own business associate agreement. You're not wedded to the BA agreement that has been developed by HHS, but it is certainly a good platform to use. And we've provided a link here to the BAA template on the OCR website. And what's also important is to evaluate and make sure that you're identifying and capturing all the appropriate relationships with contractors or vendors to make sure that you have a business associate agreement in place every time that you have a relationship in which it is needed. So so as you are creating and developing vendor relationships, you should be asking yourself, is protected health information being used or disclosed to this vendor as a part of my relationship or part of my activity with this contractor? And if so, do I have a business associate agreement in place before the PHI is being used or disclosed? And it's a good idea to have some type of process in place, whether it's a tickler on your information system, or it's a process step that you made in your internal administrative structure to make sure that you're identifying, someone's reviewing and identifying where these relationships are being created. So one way to assure that you're getting appropriate management of your vendors is to consider how as a covered entity or a prime contractor who's a business associate, how you're assuring that your information is being safeguarded and that you fulfilled both your legal requirements and you've taken the appropriate measures to limit or to manage what information is being shared with organizations, and how you can protect your organization from a business associate who's not fulfilling their obligations. So there are a number of steps that you can take. The first is to make sure that you're identifying and limiting the type of information that you're sharing with your business associate. So, for example, if you're using a business associate who's going to be providing billing for an emergency department, then the organization, the healthcare provider, should only send the information that's necessary to fulfill that purpose. So in other words, if you're hiring a company to do the ED billing, there really isn't a need for the billing company to have access to the entire health record. They only need access to the information that is to carry out what they are fulfilling. It's taking the minimum necessary policy and applying it to the information that you would share with your with your business associate. Put in place appropriate solicitation or request for proposal processes that clearly delineate the requirements and the steps that the business associate is going to have to take to safeguard and protect the information, and make it a part of a submission to the RFP, the measures that the covered entity either has in place or will put in place to assure that the information will be protected. And you could also ask what security risk activities the business associate or prospective contractor has taken. In the master agreement and in the business associate agreement with the that's being proposed, make sure that all of the requirements and safeguards that are required in a business that are set out in the HIPAA privacy and security rules, make sure that they have been incorporated as a part of the agreement with the vendor or contractor. Once the contract or relationship has started with your vendor, do some follow-up. Make sure that they are fulfilling their obligations to safeguard information. Make sure they're living up to their to what they've promised in their agreement, as well as how they're meeting the obligations under the privacy and security rule. This is not required under the HIPAA privacy and security rules for the covered entity, but this extra step allows some assurance and puts you in a better position to manage your overall relationship with your vendor. So make sure that they're performing a HIPAA security risk analysis, that they have appropriate controls in place to back up a copy of the data, assure that they have some type of incident response process in place, and that they have the procedures in place to assess whether an incident is a reportable breach, and the processes that they would take to notify you in the case of a breach. And also, make sure that you're prepared for when the when your relationship with the vendor is going to end. All business relationships end at some point. And when you are in a position where you are responsible for safeguarding protected health information, it's incumbent upon you to make sure that you've got processes in place so that when the relationship with your vendor ends, that you have addressed how the information is going to be returned to you, or is it going to be disposed of securely and appropriately. So if you're a business associate, there are certain things, certain steps that you should take. You should put in place privacy policies, the privacy policies that are required under the privacy rule for business associates. Not all of the standards and implementation specifications of the privacy rule are going to apply to a business associate, but you must have in place at minimum those provisions regarding uses and disclosures, as well as any permitted uses and disclosures that you're taking on for the covered entity. An example would be if you're a business associate who's taking on the responsibility for responding to patients' requests to have access to their health information, you're going to need policies and procedures that mirror those responsibilities in the privacy rule. You're going to have a process in place for how individuals put those requests in, the timelines for considerations, the appeals process for any denials, and the implementation specifications for actually providing access to that health information. In addition, to meet the requirements of the security rule, you have to evaluate the how to reasonably safeguard health information and the requirements of the security rule, that you have appropriate safeguards that are reasonable and appropriate for the size and scope of your organization. And the baseline approach is to conduct the security risk assessment that is in the security risk management process in the security rule. So to perform a security risk analysis that takes a objective look at the threats and vulnerabilities to information systems that handle e-PHI. Now, many business associates have multiple information systems, but in their relationship in working with a covered entity, only one of their information systems will actually handle protected health information. So the scope of the risk analysis can be limited to those information systems that actually have access to protected health information. One thing to remember is that the risk assessment is an ongoing process of analyzing threats and vulnerabilities, and then determining the impact or magnitude, and then reducing the risk of those threats and vulnerabilities. One important aspect that we see, particularly when we're looking at enforcement activities by OCR, is that they are really focusing in on the documentation or the lack of documentation that an organization has for their risk analysis. And so it's really important that you put on paper or that you document in some way that you have gained an understanding of the risks in your environment. You've set out a plan for how to correct them, and that when you are looking at the implementation specifications that are addressable under the HIPAA security rule, that you've documented how you have taken your analysis of this. And if you've chosen to address the implementation specification by using another set of controls, by demonstrating how those alternate approaches are just as protective to safeguarding the e-PHI as the recommended or addressable implementation specification. And it's important to remember that all your actions that you're taking to show compliance with the HIPAA privacy and security rules, that you retain this documentation for 6 years. The documentation retention period under the HIPAA privacy and security rules that is the same for covered entities as it is for business associates. That's the 6-year period. So this is just a brief guide as to how to perform a risk analysis. OCR adopted the NIST approach to identifying threats and vulnerabilities and addressing risk. And in 2010, OCR developed a guidance that lists out a 9-step process, or 9 steps that have to be incorporated into completing a thorough and complete risk analysis. And this chart here essentially compartmentalizes it into 3 big groupings to gather information about your system and about the threats and the vulnerabilities that are present in your environment. Take action to analyze your approach to how your processes and technical, physical, administrative controls address those threats, and to develop plans to reduce the risk for any gaps that are identified through your risk assessment. Another important consideration, particularly for business associates that haven't dealt with vendors who are handling protected health information, is to train your workforce, to make them aware of the basic HIPAA privacy and security requirements, and to make them aware of and to raise awareness of the policies and procedures that you've created in your organization. And specifically, under the security rule, you as a business associate, to meet the requirements, you have to engage in creating and providing security awareness training on how your workforce can log into an information system that maintains protected health information, how to use passwords and manage passwords and unique user IDs, how to use antivirus and anti-malware controls, and how to understand and install updates to information systems to make sure that they stay up to date with critical patches and anti-malware and anti-spyware protections that you have put into place. Another important aspect of training is that you have to document when the individuals on your workforce have obtained training, and you have to maintain that documentation like everything else, to comply with the rule, you have to have those records for 6 years. Pardon me. But what's important is that you have to also document that this training was provided to the individual at around the same time that they were given access to PHI. This is also true if you have workforce members that are moving into and out of roles in which they're given access to PHI. If someone in your organization is moving to a new role, or you're taking on a new client in which they're now handling PHI, you have to be able to demonstrate how this new responsibility, this new activity, how this workforce member has gotten the appropriate training on how to safeguard e-PHI and awareness of your policies that you've put in place. So I wanted to share with you some basic tools and resources to help identify what the requirements are, and also how to help you develop a risk assessment, as well as sample privacy and security policies that are available for use. The two risk assessments, one is a tool that's specifically geared for small providers and smaller business associates, generally an organization that has 15 or fewer workforce members or healthcare providers who are going to be accessing information can use the risk assessment for small providers. If you're a larger organization, you should attempt to use the HIPAA security risk assessment tool that's available through NIST. So with that, I would like to offer an opportunity to ask questions. Jana, if you can help me with that, because I am not seeing a chat screen available to me. So if you could share any questions that have come in, I'd really appreciate it.
Of course. One of the first ones I saw was asking about the presentation. And yes, we will be sending that out to the participants afterwards. And then another question I saw was, some cloud computing providers use vendors that store data outside the USA. Is there anything in the HIPAA rules that prohibit offshore storage of data?
That's a great question. The rule itself does not prohibit the offshoring of data. But there are important considerations. The Office of Inspector General did a review that was released last year, in which they reviewed Medicaid, state Medicaid programs that use contractors that offshore data, and they called out the fact.
See what is going on. We've been in. Okay, I'll just try to play it dumb and see what we can do.
Okay, I'm sorry, David. I took people off of mute so they would have the ability to ask questions, but not everybody has their mute button on, so please be sure that you're muted at this time.
So the OIG called out specific.
Yeah, I understand. Okay. Hey. So.
Please mute.
Why don't you give?
Yes, I'm going to mute everybody again. Sorry, David.
Give us any. Let me find out and let me know.
So the OIG called out specific issues that you should consider, and you should identify which contractors, which subcontractors or contractors are offshoring the data, and consider whether or not you can enforce the provisions of your BA agreement to protect the data in case there's a breach or to safeguard the information. So, for example, if you're using a contractor who's in the European Union, the EU has very strong controls on the protection of information, and you'd be able to have some assurance that the contract or a vendor who is holding your information would be required to safeguard it, just as you would. But if you have a contractor or vendor who's in a country, say China or Russia or India, where there aren't comprehensive controls to safeguard data, that you would probably have challenges enforcing the U.S. standards over those contractors.
Okay, thank you for that answer. And then another question I received was, can an organization perform its own risk analysis to meet the HIPAA security rule requirements? Or is it required that the assessment is conducted by an outside company?
The rule does not require that the organization, that a vendor or contractor have or hire a third party to perform the risk assessment. The challenge, though, is that many business associates and vendors and contractors don't have the resources to do a comprehensive risk assessment. So take a look at your own organization and evaluate how the type of information that you're using or holding for a covered entity, and also evaluate the complexity of your organization. And if you are a complex organization that has significant IT resources and limited staff resources, then it may be of value to you to bring in a third party to do a comprehensive risk assessment, outsource, if you will, the activity. But if you're a small organization or you don't handle electronic protected health information, then if you're not handling e-PHI, then you don't have to fulfill the requirements of the security rule. That requirement only extends if you're handling electronic protected health information. And if you're a small organization, say 2 or 3 folks, and you have a limited information systems, not a very complex activity for you, then take a try in using the small risk assessment that's available on healthit.gov, and we provide the link in the slides.
Okay, and another question. I think we have time for one more. The question that I have for you is, if a BA does not handle PHI, do they still need to develop a security program?
So I think I briefly touched on this just a moment ago. So if you're a business associate and in your work for a covered entity, or if you're a subcontractor to another business associate, and you're not handling electronic protected health information, I'll use an example. If you're a waste hauler, or if you are a record storage company of paper records, then the rule does not require you to comply with the requirements of the security rule. The security rule only extends to covered entities and business associates that are handling electronic PHI. However, you still have to put into place the appropriate privacy rule controls on uses and disclosures of protected health information. And you're also going to want to show how you've put appropriate administrative safeguards for the physical security of the paper PHI that you are protecting. That's a great question.
Okay, well, that puts us very close to the top of the hour. I want to thank everybody very much for joining us today, and a big thank you to David for addressing all of these compliance requirements and strategies for business associates. We hope to hear from you soon, and like I said, we'll get that presentation out to you later this afternoon or tomorrow.